Law School Secrets Series number 10, Crimes Against the Person, Part 3, Expanded Homicide. Welcome. Before we begin, I'd just like to say thank you to all my subscribers and viewers. Please like, share, and subscribe. Gandhi said, "Be the change in the world you wish to see." Law is an opportunity to practice that higher purpose. Now here you can just you can pause if you want and read this, or you can move on ahead. But I'd like you to reflect on the law and study of law as something that is quite intricate. And also keep the prize in mind. The prize is passing the bar. I'd like to just quickly say a quick word about passing the bar. I am focusing on California bar, but many of the laws, you have to know the laws across the board anyway. And in the California bar, there's the first year bar exam, and that first year bar exam can be quite challenging. As a matter of fact, only 10 to some, sometimes less than 10%, but usually between 10 and 30% of all the students that go on to take that pass it. Now, not all law schools make you take that, but there's a fraction of law schools that do in California. The other regular bar, the passage rate last year, I was looking at a website, was only 60% for California bar, and I was looking at other states, and I was looking at the prestigious law schools, and generally speaking, the California bar proves to be the hardest of all the bars that I was examining in the United States, with people from regular and Ivy League schools only having a 60% pass rate in California. I consider like Berkeley Ivy League, but I don't know, everybody might categorize stuff differently. I looked at other schools like Yale and Harvard, and they're like in the 70%, 72 or something. So just realize that you really have to be on your game, and you have to really train your mind. And okay, so let's get started. Here's the outer outline that we're working from. And if you want to pause and write this down, if you haven't already, this is what I'm following from. We're still on homicide. We're getting into the nitty gritty of that. And let's see. So again, it's part 3 of the homicide, crimes against the person category. Now, if you're filling in your outline, this is where you want to be orientated to. Now, I'm going to reiterate last time on the homicide, just to brief, I always do a quick brief overview of what we did before. According to Singer and LaFond, at common law, homicide is the unjustifiable and unexcused killing of a human being. Many states have moved away from using malice aforethought, substituting other terms for the defendant's intent or state of mind. In essays, you might want to discuss this. By the 19th century, USA, most jurisdictions had 2 umbrella categories: homicide, murder, or manslaughter. And then with the manslaughter, they had 2 categories: voluntary, often characterized as heat of passion killing, and involuntary, usually done unintentionally or with reckless disregard. For example, a car accident causing a death. Some states might call this vehicular manslaughter, but it otherwise could be called involuntary. And the MPC has a category which it might fall under, which would be called negligent homicide. So it's further divided into a category called first and second degree murder. First degree is premeditated deliberate murder, or some murders in the commission of a felony. And then all other murders are second degree murders. Now, the reason this is important is because when you get down to sentencing, there's capital punishment in some states. That's where you kill a person. They'll call it capital murder. if you kill a person, you're going to get put to death. So the stakes are different depending on the degree. And that's why we need to know the categories. Okay, so homicide is the killing of a human being by another human being. Shooting of a dead person is not homicide. The death must be caused by the defendant. It could be destruction of a corpse. If the person believed the person was dead, was alive, and then he shoots him to kill, he possibly could get attempted murder. Suicide, of course, is not homicide because it's not caused by another person. Well, here's something we really need to discuss. When does human life begin and end? Start with, when does human life begin? Recall in one of my earlier, very, very earlier videos on criminal law in this Law Secret series, we discussed Keeler versus Superior Court in California. Now, we discussed it in a different context because it illustrated ex post facto legislation. That's because the law changed after the hearing was heard, and he was not convicted for murder of a baby that would have been born viable, but the law changed afterwards. Well, this question came up in the court. When does human life begin? And they looked to the statutory law, and the statutory law was what the traditional statutory law is. A human being, life doesn't begin, you're not a human being until you're born alive, according to the law traditionally. Of course, modern medicine has come, and we've learned more things. So, in People versus Chavez, moving on to the next case, a single woman was living with her parents. She'd already had a baby before. She was 21 years old. She went and gave birth in the toilet. Now, she didn't want her parents to know because she didn't want to get in trouble. And it's really pretty gross, if you ask me. But they go into detail if you read the case. The baby wound up in the toilet, then she put it on the floor, then she cut the cord, and the whole time she says the baby was not alive. It didn't appear to be breathing. She didn't help it to try to breathe. She cleaned up the mess. She went off on her way. Well, she wrapped the baby up and hid the baby because she said, oh, the baby's dead. And anyway, she was convicted of murder. Now, or manslaughter in the death of the baby. Of course, that was 47. Now, look at the dates. That was 30 years, 37 years. No, wait, less than 37, excuse me. So that's in the 40s. The other case is in the 70s. The next case that might discuss this is a man accidentally shot and killed his girlfriend. She was 8 months pregnant. He's saying he accidentally shot her. She died. The baby was born alive and died. And his name was Lawrence Cotton, and he was convicted on 2 counts of murder, or it was called reckless homicide, excuse me. One for the baby, one for the mother. So they said, hey, I think how many months was she? Oh, I didn't write it down. Okay, well, oh yeah, it was 8 months. Okay, so they considered in 1970 in this case that the baby was a human life. Do you see how you're seeing different interpretations of when human life begins? Now, some states characterize killing a baby that hasn't been born yet or about to be born as feticide. They call them feticide laws. Okay, let's move on to the second component. When life ends. When does life end? There's death. Okay, who caused the death? When does death occur? Death traditionally was defined when breathing ceased and heart stopped beating. Modernly, death occurs when brain ceases functioning. Now, the Uniform Death Act defines death has occurred when the brain has suffered irreversible cessation of all functions, including the brain stem. So you can't have any brain waves according to them. Now, with organ transplantation on the horizon, more and more, this gets a little dicey. The law's kind of changing. Well, you got to keep those organs fresh before you transplant them. And how much of a brainwave does a person have when you're harvesting those organs? You know? Well, in 1979, a doctor, Ferraro, was convicted of criminal homicide for harvesting a vital organ too soon. They're getting the heart out or whatever it was, I can't remember. But his action was classified as hastening the death. Corpus delicti, the body of the crime, as in the proof of death, not necessary to have the corpse. Notice. Now, Rogers versus Tennessee, Justice O'Connor said, the year and a day rule is widely viewed as an outdated relic of common law. The year and the day rule, discussed in a prior video, has been abolished in many locations because of the new life support technology. So this is what might come up in a court case, or one of the hypotheticals. When is death occurring? And you're getting into the causation element. Now recall there's 3 classifications of homicides: justifiable, excusable, or criminal. Justifiable homicide is a perfect defense. Those that are commanded or authorized by law to kill. For example, a soldier during time of war, an officer that shoots and kills a felon during a bank robbery, a non-officer kills someone in self-defense in front of others. Now this is, you cannot have deadly force with non-deadly force. It's not considered, you won't get away with that. And just depends on the jurisdiction again. Excusable homicide. This is an imperfect defense for those which there was a defense to criminal liability. An insane person, unaware, kills a victim, but the defense of insanity. Now, in the future, I'll go over these insanity defenses. Now, also, if the defendant kills the victim, believing he has a right to do so, but he doesn't, the defense of mistake is an imperfect self-defense, and it could be voluntary manslaughter rather than murder. Remember we were talking about degrees earlier? Okay, so generally at common law, there's 4 types of murders, and we'll get into MPC a little more later. Intentional murder, that is the intent to kill, express malice, is subjective. The prosecutor has to prove intent beyond a reasonable doubt. The conscious objective of the killer to take a life. In other words, that's what he needs to prove. Now, the natural probable consequences inference has been contradicted in a case that set a precedent, by the due process clause of the Constitution, because it shifts the burden of proof from the prosecutor to the defendant. See Sandstone versus Montana, 1979. It is reasonable to infer a person intends the natural and probable consequences. Thus, the jury may be instructed that they may not presume this, but that they may infer intent based on the facts set forth. Now, intent to cause serious bodily harm, even if, this is the second category, they did not intend to cause death. The grievous bodily injury, some statutes use this term, which imperils life. Now, I am going to read to you from this book. Let me grab it. It is the black letter outline. I'm going to read you the 3 because I can't say it any better. And this is for educational purposes under fair use. Okay, page 308. It's in the back of the references. Depraved heart. The general rule: a person who acts with what the common law colorfully describes as depraved heart, or an abandoned and malignant heart, is one who acts with malice aforethought. If a person dies as the result of such conduct, the actor is guilty of murder, although the death was unintended. What is depraved heart? Extreme recklessness. Common law judges did not provide a clear definition of depraved heart or abandoned and malignant heart behavior. In general terms, it is conduct that manifests an extreme indifference to the value of human life. Although no single definition of such extreme indifference can explain all of the common law decisions, today most courts would probably agree that an actor manifests an extreme indifference to the value of human life if he consciously takes a substantial and unjustifiable foreseeable risk of causing human death. In short, depraved heart equals extreme recklessness. The common law characterized such conduct as implied malice, as distinguished from intentional killings, which involved express malice. Examples: although each case must be decided on its own merits, the following facts have supported a charge of extreme recklessness: failing to properly control a pit bull that has a history of threatening and attacking people. People versus Noller, California, 2007. Knowingly placing a loaded gun at the victim's temple, after which the weapon goes off accidentally. People versus Love. Playing Russian roulette, Commonwealth versus Malone. Shooting into a moving train for no apparent reason other than to cause mischief, Banks versus State, 1919. And speeding, driving in an intoxicated condition and ignoring stop signs and red lights, Pears versus State, Alaska. The statutory approach in states that are dividing murder into degrees pursuant to the traditional model, a depraved heart homicide ordinarily is second-degree murder. Now, let's move on to the fourth of the categories, felony murder rule. This is a murder that's committed during a felony or an attempted felony. Death must have resulted from the commission or the attempt of the felony. A word about the deadly weapon doctrine. This is the intentional use of a deadly weapon. It infers intent to kill. A deadly weapon is any instrument. It can be a baseball bat, a wrench, a rock. And in limited circumstances, it can be part of someone's body. For example, an expert karate player with a black belt. Here's some examples. Driving a truck into a crowd celebrating the 4th of July. The truck is the deadly weapon. Firing a gun during a movie in the middle of a movie theater. Hey, that's considered attempted. If you didn't shoot and kill anybody, it's considered attempted murder. Okay, a black belt breaking a person's neck using one of his expert moves. His hands are the deadly weapon. Back to the basics. Elements of murder. Generally, it can be broken down to the main elements of the crime. If you want to pause, you can write this all down. And this is about all I've got for today. It's going to be continued. We can't all fit it in one little lecture or tidbit. But anyhow, here's the references and the images. And I just want to take a minute again to thank you all. I wish you all well in your endeavors. Namaste. Thank you. Please like, share, and subscribe. Put your comments in the comment box below.